Well, the Supreme Court of Appeal in Bloemfontein will hand down judgment in former President Jacob Zuma's medical parole appeal on Monday. Zuma and the Department of Correctional Services challenged the Pretoria High Court order, which declared his release on medical parole irrational, unlawful and unconstitutional. The DA submitted to the SCA that former Correctional Services Commissioner Arthur Fraser erred in believing that he was entitled to release Zuma on medical parole. In June last year, Zuma was handed a 15-month prison sentence by the Constitutional Court after he had defied its order to appear before the State Capture Commission. Now, the DA argues that medical parole is intended only for inmates who are likely to die or cannot take care of themselves, and that Zuma did not meet these legal requirements. The Helen Suzman Foundation argues that Fraser failed to explain why he had overlooked the recommendations of the Medical Parole Advisory Board that Zuma should not be released. Now, Zuma was incarcerated at the SCA Correctional Centre in July 2021 and released on medical parole in September last year. All right, now let's discuss this. We are now joined via Zoom by legal analyst Mpumelelo Zikalala. Thank you so much for your time this afternoon. Now, arguments heard in front of the full bench of the SCA were largely centered around the fact that Arthur Fraser erred in law and in rationality when he dismissed a recommendation by the Medical Parole Advisory Board that former President Zuma did in fact not qualify for medical parole in the first place. So what can we expect in the SCA's judgment tomorrow?
I think the SCA is going to go back and say, what does the law say when it comes to decision makers? Now, here we are guided by the Constitution that says anyone who's a decision maker has got to make a decision which is done or principled by three things. The decision must be lawful, meaning that there must be an enabling provision which would allow you to do that. In this case, it's the Correctional Services Act. Number two, it must be reasonable, or the rationality part of it must be there. So you must then say, out of all the factors that has been presented to me as the decision maker, would a person in my shoes make this particular decision? And lastly, when it comes to procedural fairness, all the things that have to be done procedurally must have been complied. Now, the two things which are at play here is the lawfulness of the decision, and secondly, the reasonableness of the decision. When it comes to the lawfulness, I think the applicants in this case, they are going to say, or the court is going to say, yes, you do have a Correctional Services Act, which then allows you as a commissioner to sign on the dotted line and be the final green button pusher when it comes to people who've been released on medical parole. However, when it comes to medical parole, it's a bit different. You do so upon the advice of medical practitioners that have been trained in it, that have various experience in deciding whether a person is medically ill or too medically ill to be able to take care of themselves, or to be in a facility that can be able to take care of their medical needs within correctional services. In this case, it was clear that the report was saying one thing and Mr. Arthur Fraser said another. So I think the court is going to say your decision in that process it was flawed, was not in line with the rationality of the process, and it has to be declared unlawful and maybe unconstitutional. The results of that, which is what I think the Concord is going to differ with the SCA is going to differ with what most people would then think is going to follow after the decision, is to say, we are not going to punish the former president in terms of saying to him, go back to jail, because here, let's see him as an innocent applicant. His only act that is involved in this matter was to simply apply. He did not take the decision. The person who took the decision is the one that should be punished. We cannot punish him for the sins of another person. And then secondly, let's also look at the term detention. Do you have freedom to go wherever you want to go? The answer is no. And while he was out on medical parole, still he was still regarded as a prisoner, still regarded as being his rights, his freedom of movement was sort of deprived. So he has served his sentence in a technical manner, and sending him to jail simply because the decision maker took the wrong process, took the wrong decision, is certainly not going to be in the interest of justice.
I want us to look at some of the scenarios that you are mentioning, but before we do that, the Supreme Court of Appeal must also, we understand, decide whether the High Court, the Pretoria High Court, was correct to find that, the time spent by the former president on medical parole should not count as part of his sentence. But I think in your statement that you made earlier, in that, the SCA will not necessarily want to punish the former president because it essentially was not his decision that was made in the first place.
Definitely, because if you look at the term detained, it simply means that I cannot go anywhere where I want to go at my own reasonable time or at my own time. I'm always subject to some other individual giving me permission to do so. Now, if the former president at the time that was in parole could not decide that I want to go on holiday in Dubai and simply pack his bags and passport and go, that certainly means that he was detained. So the SCA is going to be very careful in terms of saying, let's not punish the innocent applicant in this case. Let's punish someone who has taken the wrong decision. And the results of that, maybe there may have been some benefits here and there. However, there's not too much benefit because anyways he was punished because his rights of freedom of movement was still infringed or was deprived of being able to go in anywhere the way he wanted to go. So he wasn't free to move in a manner in which he wanted to go. So giving out that judgment or saying you must go back to jail, certainly it's going to be similar to double jeopardy of being punished twice, especially for a decision that he didn't take at the end of the day.
Mpumelelo, let's now go back to some of your earlier comments made. Now, withstanding, of course, the Pretoria High Court having declared, the former president's release on medical parole irrational, unlawful, and unconstitutional. Now, your earlier comments saying, of course, that be that as it may, where the SCA will differ is, in fact, in saying, well, but that can't be the former president. The former president's fault, and it won't, in fact, punish him. But let's look at some of the, parameters in which it can then act. I mean, to what extent, for instance, can the court, in its decision, consider just some of the consequences, of placing Zuma back in prison? You've made some of those points, but I'm talking specifically here in the face that, there are renewed fears that if he is again imprisoned, we might see scenes that we saw, the unrest scenario of July 2021. To what extent does that also weigh in heavily in the court's decision?
I think it wouldn't weigh that much because the courts of the justices are simply there to say all that we're here to do is to make sure that there's compliance with the rule of law. So the way in which, or the methodology that we're going to follow is, what does the law say? Let's look at our constitution, legislation, and common law and decided cases. Let's look at, was this particular decision taken in compliance with that, or was it not in compliance with that? However, in the decision that we're going to give out, or the order that we're going to hand at the end of the day, that particular order must be in the interest of justice. There must be some sort of justice which is going to be seen, and part of this justice is to say, we are not going to be intimidated by external factors which happen outside court. Our decision is purely based on the legal principles and legal prescripts that have been employed to look into this matter or through and to comply with. And then third, we are not going to punish a person who is not liable for the injustices or the wrong decision that has been taken. So the innocent party in this case, regardless of how peculiar or how odd it may sound, that this decision is wrong, but you're not going to punish you in that particular manner. It simply means that it must be in the interest of justice that that adverse decision must be taken, solely to protect the integrity and the human being that did not actively participate in a wrongful manner in this whole decision-making process.
So, where then does it leave Arthur Fraser? Because, I mean, in your argument of who the decision makers are, it's clear that he, in fact, contravened the Medical Parole Advisory Board's decision. Where does it leave him legally?
That's where the punishment should then be directed. Now, we are not dealing with a criminal matter here, so you can't be sent to jail for contravening any section of the Act unless there's a section which specifically speaks to that when it comes to commissioners making their own decisions. If there are any costs which are going to be occasioned by these proceedings, I think the costs are going to be upon him. And you may even see a personal cost order being granted against him in terms of saying, had you applied your mind as a responsible and reasonable commissioner in this particular case and not thought about any other interest rather than the interest of the department and the work in which you are doing, we wouldn't even be discussing this matter. So this case shouldn't be here if you had done the correct thing. So to make sure that we remedy that, we are going to make sure that you are the one who's going to pay for the cost. Other than that, there's nothing else in which he could be punished with. Of course, depending on how the notice of motion was drafted in terms of the relief that is being sought by the applicants in this case, or the initial applicants. So if what they went to court to ask for was to simply say, make sure that the decision is wrong and the former president goes back to jail and it ends there, If it can't be, if it can't be done in that particular manner, then there's nothing else they can be able to go away with. Which is why it is important that while drafting your notice of motion and asking the court what to do, make sure that you're able to cover all eventualities, just in case it doesn't go within your first prize, you still have a second prize to go to.
Just as a final, comment, I'd like to pick your brain on this one as well. The DA maintains, of course, that, this is a case of principle, that the medical parole appeal is a test of the principle before the law, and saying, of course, that some people seemingly are above the law.
There can be no greater principle than the principles of justice, of saying what is just, what is right, and what is correct. And it cannot be said that someone is going to be punished twice just because someone else took the wrong decision. You can't be punished for somebody else's sins. So you should be punished for your own wrongdoing. You should be punished for your own decision-making process that you did not follow. And it shouldn't be anybody else other than you to take the blame and also to take the punishment which is going to follow. It wouldn't be just to have a person who is going to simply make an application, provide all the information that needs to be provided. And just because the decision maker has then provided incorrect decision-making process, then leads to an incorrect a decision, and then that particular person should be punished. And then also linked to that, this following factor must be taken, which can't be ignored, to say, at the time that the former president was released on medical parole, he was still a detainee, so was still detained. His freedom of movement he was still deprived of the right to move freely, even inside South Africa, because he couldn't go anywhere without asking for permission. So if you say, let's take a decision which is in the interest of justice, a decision which is in the interest of justice is to say, let's separate the two, let's unmuddy the waters and look at it clearly and say, who is wrong and who is supposed to be punished? And the person who has gained indirectly or maybe gained an advantage here and there, he can't be punished just because he's the one who's on the receiving end.
Mpumelelo, thank you so much for your time this afternoon. Really do appreciate it. Mpumelelo Zikalala is a legal analyst, of course, weighing in on this matter, saying tomorrow's decision by the Supreme Court will then be in the interest of justice. Of course, we are talking about the Supreme Court of Appeal in Bloemfontein will be handing down judgment in former President Jacob Zuma's medical parole appeal. That is all happening tomorrow.